Good morning. I hope you're all well. I'm Ian McGlashan, part of the employment law team here at Watershed, and my colleague Lindsey Murray will also be presenting today. Now, of course, we'd love to be able to meet you all in person, but this is the next best thing. So I'm welcoming you into my home, so perhaps it's even better. Now, this is our second case law update. And one of the reasons we do this is because case law helps us manage risk. If I sack someone in these circumstances, what would a court say? So if we look at the next slide, you'll see what we're going to be covering this morning. So if we start with 2P, can one employee transfer to multiple transferees? Because 2P is simply not complicated enough. Unfair dismissal. Can you dismiss someone fairly if you follow no formal procedure at all, if it's for some other substantial reason? When might a tribunal pay a dismissed employee's wages before they've even heard the case? And Lindsey's going to be telling us when the requirement to cover costs can justify discrimination, whether it can be a reasonable adjustment to promise an employee that they'll never have to work with a colleague again. For some reason, Lindsey's particularly interested in that one. I don't know why. Is it discriminatory to identify a pool of talent for future promotion? And we'll end by looking at what case law developments we can expect later this year. So there's something for everyone there. Now, of course, we know that your time is valuable, so this session will last around 35 minutes. Do get in touch with me or Lindsey if you want to ask us a question or get a copy of the slides. Our email addresses will be on the last slide, so we'll give you a chance to note those down. Or you can put your questions and email address in the Q&A function and we'll come back to you. Don't worry, only Lindsey and I will see it. We'll also put the session on YouTube, although we might disable the comments. We'll see how it goes. So if we go to the first one. So the first question we've posed, can one employee transfer to multiple transferees? So if we start by thinking about 2P and what it is, it applies to a transfer of an economic entity which retains its identity. So the rights and obligations under the contract of employment transfer from the outgoing employer, the transferor, to the incoming employer, the transferee. It's amazing how easy it is to get those two mixed up. So if a business or part of a business is acquired by someone new, the employee keeps their job. Now, one example of 2P is a service provision change. So if we think about what is a service provision change, we've got the three dictionary definitions there, if you like. But if we think of that in practical terms, think what it means. So let's say that you decide to stop cleaning your offices yourself with your own cleaners, but instead engage a cleaning company to do it for you instead. That would be an example. That's the first bullet. Or the second one, you replace your cleaning contractors with another cleaning company. Or the third one, you terminate the contract with your cleaning company and decide to do the cleaning yourself. So bringing the work back in-house. Those will all be examples, practical examples of service provision changes. Now, just before we look at the next one, just let you know that the case we're going to look at is an ECJ case, a European Court of Justice case. Now, the standing of EU law and European Court of Justice decisions after Brexit is outside the remit of this session, but do email me if it's something that interests you. Now, we start by looking at the directive because that tells us what our domestic law is trying to achieve. So when we're dealing with 2P, we're in the hands of the Acquired Rights Directive. And what that does is it safeguards the rights of employees on a change of employer. So 2P should be doing the same. We'll look at the particular case on the next slide. And this is a case of ISS versus Goverts. Now, ISS, the company, the employer, was responsible for cleaning and maintaining various buildings in Ghent in Belgium. The claimant, Miss Goverts, was employed as a project manager, and her work was spread between 3 lots: museums, libraries and administrative buildings. After a tender, ISS lost the contract, but because there are 3 lots, it was split up. So 2 lots transferred to one company, Italian. The 3rd lot transferred to Cleaning Masters, and Miss Goverts was assigned 85% to the first 2 lots and 15% to the 3rd lot. Now, ISS dismissed her and said to Italian, "She works for you now." Italian disputed the transfer, and that's why the ECJ had to look at it. And we'll look at the 3 questions that they posed on the next slide. So the first question: should employment transfer to each of the transferees pro rata to the extent of the employment of the worker in the part of the undertaking acquired by each of the transferees? So that was the first question. That's how the ECJ put it in English. So does it simply mean 85% of her contract goes to Italian and 15% to Cleaning Masters? The second question: should employment transfer in its entirety to the transferee, the incoming employer, that acquired the part of the undertaking in which the worker was principally employed? So again, in English, so she goes to Italian because they got 85% of the work. The third one: if the provisions of the Acquired Rights Directive cannot be interpreted in either of the above ways, whether there's no transfer to any transferee of the rights and obligations under the employment contract. So if we can't safeguard the rights of employees on a change of employer, do we say that there's no transfer? And we'll see what they decided on the next slide. Now, the ECJ rejected the second and third interpretations and held that the first interpretation was the correct one. And they went back to the directive. They said that the Acquired Rights Directive is intended to safeguard the rights of employees on a change of employer by enabling them to continue work for the new employer on the same terms and conditions that were in place with the old one. The contract continues unchanged with the incoming company, the transferee, and the workers aren't put in a less favourable position as a result. They had to protect the worker, but they also had to be fair to the incoming business too. There had to be a balance. So we'll look on the next slide what this means in practice and really the nub of the decision. Effectively what they're saying is a full-time employment contract of a transferring worker can be split between the transferees into a number of part-time employment contracts pro rata to the tasks performed by the worker. But they've left a number of questions unanswered, because how does this work in practice? How in practice would an employee split their time? Now, they could consider the economic value of the lots to which the worker was assigned, or they could do it on a time spent basis, looking at the time that the worker devoted to each lot. And then, of course, we've got questions like, well, how do we treat annual leave? So they haven't answered those questions. So what that means is that when you've got a fragmented 2P situation, which a number of you will face, it's going to require careful navigation. And you've always got to remember that overriding qualification that the ECJ mentioned, which is that the worker must not be in a worse working situation. They mustn't have worse working conditions after the transfer than they did before. So it's going to involve a degree of pragmatism. Now, currently our law goes with the second scenario, which is the transferee that takes on the greater part of the activities takes on the employment contract in its entirety. So this case might lead to a change in the tribunal's approach to similar cases in future, and there might be a shift towards dividing an employment contract between multiple transferees. So we'll have a look on to the next slide and we'll see another case, which the question that we're answering there is, can a dismissal for SOSR, some other substantial reason, be fair even if there's no procedure? So we're familiar with the concept in an unfair dismissal claim that there are potentially fair reasons for dismissal. So reasons of capability, conduct, redundancy, contravention of a statutory duty or restriction. So for example, let's say you've got someone who's employed as a dedicated driver who loses their license and there's no other job, then to let them keep working would be contravening a restriction. If none of these apply, you've got the catch-all of some other substantial reason of a kind, such as to justify the dismissal of an employee holding a position which the employee held. That's how it's written in the statute. So what if, for example, you've got two employees who can't stand each other and it's impossible for them to work together? You're still under a duty to act reasonably, but can you be held to be acting reasonably if you follow no procedure? We'll look at the case on the next slide. And it's the case of Gallagher versus Ebelio Scott Rail. Now, Mrs. Gallagher's relationship with her line manager soured after they argued about salary and recruitment. In short, she thought that she should get more money, her manager didn't. They met twice to discuss their relationship, and the only thing they agreed on was that they couldn't repair their relationship. Effectively, a Humpty Dumpty situation where all the king's horses and all the king's men couldn't put their relationship together again. In this case, Ebelio was trading at a loss and they needed to act quickly, because these cases, when you're dealing particularly with some other substantial reason, they're always fact sensitive. So Ebelio was trading at a loss. They needed to act quickly. There were no signs that the relationship could be repaired and no alternative roles for Mrs. Gallagher. The line manager dismissed Mrs. Gallagher, citing an irretrievable breakdown of working relationships. There was no procedure, no right of appeal, but they did pay her 9 weeks' pay in lieu of notice. So on the next slide, we'll see what the tribunal decided. And they rejected her claims of unfair dismissal and disability discrimination. She said that her disability was menopausal symptoms. The tribunal said that the problems in their relationship started before she began to experience those symptoms, and the business didn't know of them, nor could it have known of them. So they had to look at causation. They had to look at, well, what was the reason that they dismissed her? And the substantial reason was the lack of trust and confidence between two senior employees. Usually, the lack of procedure would render the dismissal unfair. However, there'd been an irretrievable breakdown in trust and confidence between two senior managers at a critical time for the business. The case involved senior managers who needed to be able to work together effectively to deliver what the business required at a critical juncture. The circumstances didn't fit naturally into any internal policy. Meeting again would serve no useful purpose. In fact, it might even have made things worse. The claimant wasn't interested in retrieving her relationship with her line manager. Any appeal would have been going through the motions and it would have been pointless. But the EAT agreed, but they did warn that any dismissal without procedure should be approached with extreme caution. And I encourage you to do the same. And I'll talk about it more on the next slide. This case should very much be regarded as the exception rather than the rule. And at the very least, before dismissing for irretrievable breakdown, you should meet with the employee to talk to them about the situation. Here, there was no dispute as to the reason for dismissal, albeit that the claimant said it was linked to other matters. But had there been an argument about the reason for the dismissal, or a suggestion that it was in fact performance or capability or something more sinister, the decision may have been different. You don't know what claims a disgruntled employee might bring. Where there's an allegation of discrimination or whistleblowing, you should be particularly conscious of the heightened legal risks of dismissing without following a fair procedure. Remember, they had to fight a tribunal case followed by an appeal tribunal, so it did cost them to be proved right. Plus, the judgments published online, I'm talking about it now, so you've got the publicity to consider as well. I do wonder whether they did try to reach a settlement agreement with her. Of course, it's not something that's mentioned in the case itself, so we'll never know. But the message to take away is, even if you come across this case, is don't view it as a green light to rip up your procedures where there's a clash of personalities. It's certainly not saying that. It's very much fact sensitive. So if we move on to the final case. And in this one, it's about a little known remedy that's available to employees. So the question I've posed is, when might you be liable to pay an employee's wages whilst their unfair dismissal claim is waiting to be heard? And the answer is when a court grants an employee interim relief. Now, what is that? Interim relief is an order for an employer to continue paying salary pending the tribunal hearing and pending the final decision. It's only available if the tribunal decides at a preliminary hearing that the claimant is likely to win at the final hearing, and it's available in limited circumstances. So an employee can seek interim relief if the alleged reason for dismissal is because of union membership or activity, whistleblowing, activities as a health and safety representative, a working time rep, pension scheme trustee. And two examples which you might have come across recently or you might face shortly: an employee representative for the purposes of collective redundancy or 2P. And I've dealt with two interim relief hearings that we've managed to defend successfully in the last 6 months. But that's after probably only dealing with two in the previous 20 years. So it is something that is going to be happening more often. And it snowballs. The more it happens, the more people report it, the more people are aware of it. Now, if we look at the particular case that we're looking at here, Morales versus Premier Fruits. Now, in this case, it's a proposal that you might have put to your employers yourself recently. The employer proposed that staff take a 25% pay cut and 1 week's unpaid leave a month. A trade union lodged a grievance. After dismissing the grievance, Premier dismissed Mr. Morales purportedly for refusing to consent to the reduction in wages. Mr. Morales claimed unfair dismissal and said that the true reason for his dismissal wasn't because he refused to consent to the reduction in wages. It was for being a member of a trade union and for whistleblowing. And in this case, the tribunal granted the application. And the reason they granted it is because the manager in question had shown strong hostility to trade union involvement in the grievance. And remember, your business as a whole may not hold those views, but you might have a particular manager who might hold those views and might make it clear that they hold those views. So if we go over to the next slide, I deal with two things. One is to consider why it's such a powerful weapon, but also to think, well, what do you do about it? So the reason it's such a powerful weapon is a successful application for interim relief will assist the claimant, who may now be employed, to fund the ongoing litigation, and it will put pressure on you to settle earlier and for a larger sum than you might have done otherwise. As I mentioned earlier, awareness of this remedy is increasing. The employee has to show at the preliminary hearing that they've got a pretty good chance of winning at a full hearing. That's what the case law says, a pretty good chance of winning at a full hearing. And you've got to remember that in addition to the possibility of a very costly sanction, you've got limited time to prepare for that hearing. Often, when you receive notice of the claim, you also get told that there's going to be a hearing for interim relief at the same time. So you might only have 4 weeks. Sometimes it might even be before the deadline for the ET3. So you should really exercise caution when you're dealing with an employee who's asserting one of those relevant claims. If you're defending a claim, you really should make sure that you get help straight away. Put your strongest possible argument on paper. Don't look at it as thinking that you can put a skeleton argument and flesh it out later. Put your strongest possible argument on paper. Get help and gather as much evidence as you can for any preliminary hearing, just as you would do if it was for the final full merits hearing. So thank you for your time. That's everything from me today. So over to you, Lindsey.
Thanks, Ian. So the first case I'm going to talk about is Heskett and the Secretary of State. And this case tells us when the requirement to reduce costs can justify discrimination. This is a case that involves a probation officer, and he challenged a change to the pay structure that was made when there was a public sector pay freeze introduced after the 2008 financial crisis. Now, it used to be the case that probation officers could progress up 3 pay points in a year within a 23-point scale, depending on how well they'd performed that year. But the pay freeze effectively took away performance-related pay, and you could only move up 1 pay point a year rather than 3. So Mr. Heskett argued that that had a discriminatory effect on younger employees because they were more likely to be at the bottom of the pay scale, and it would take them 23 years to reach the top of the scale instead of just the 7 or 8 that it would have taken those at the top of the scale who tended to be older. And the tribunal agreed with him and said that that was right. The effect of the pay freeze was age discriminatory, but that kind of discrimination can still be lawful if it's a proportionate means of achieving a legitimate aim. Now, we know from previous cases that the desire to cut costs in itself cannot justify age discrimination. So if we look at the next slide, we ask ourselves then the million-dollar question: when is a cost saving not actually a cost saving? And the answer in this case is when the aim was to save enough costs to stop the enterprise going bust. So they'd taken lots of other steps in the probation service to cut costs that were discriminatory in lots of different ways. They knew they needed to unpick everything that they'd done, but the tribunal accepted that they were in dire straits when they'd introduced this cap on pay progression, and so it was a proportionate means of achieving a legitimate aim in those circumstances. So moving on to the next case. Now, every now and again, a case comes along that you can't quite believe that the claimant solicitors had the nerve to run. And to my mind, this case is one of them. So previous cases have established that disabled employees are not objects of charity. And so the obligation to support them in a way is in a way that enables them to continue working. So it's always been that you don't have to pay them not to work. All you have to do is make changes that it would be reasonable to make to working arrangements or duties so that they continue to keep working. And what changes it's reasonable to make depend on these 3 factors that are set out on this slide here. So if we look now at what happened in this particular case, this was an employee with 30 years service who was an analyst and business architect. That's the kind of fancy title that I one day dream of having. Now, she complained that she was being bullied by 2 colleagues and she went off sick with stress, which is a familiar story. Certainly to employment lawyers, not to me personally. That's not why I was interested in the case. She lodged a grievance and that grievance wasn't upheld. And she said that she felt physically sick and exhausted at the prospect of having to come back to work with these 2 colleagues. And we're assured in the tribunal judgment that the feeling was completely mutual. These 2 colleagues hated her just as much as she hated them. And she asked Lloyds Bank to guarantee that she'd never have to work with these employees again, and if she did, then they would pay her off with a severance package that was equivalent to redundancy pay. And Lloyd said and I don't know, some of you may have dealt with a grievance in a similar way yourselves when you've been asked this question, that whilst efforts would be made to ensure they didn't work together in the future, it wasn't possible to actually guarantee that. But they also said that they wouldn't be able to offer her a redundancy or a severance package in this scenario because her role wouldn't actually be redundant. Now, Mrs. Hill brought a claim of failure to make reasonable adjustments, and contrary to what my advice would have been, this was a successful claim. The Employment Tribunal and the Employment Appeal Tribunal upheld the claim. She was found to be at a substantial disadvantage because, as someone with depression, they said that she suffered a level of anxiety and fear which a non-disabled person who felt they'd been bullied and harassed would not. So they said that promising her that she could exit with a severance package rather than being required to work ever again with these two colleagues in the future would have been reasonable because it would have given her a backstop and it would have meant that she could continue working without fear. So that runs kind of contrary to what we've been told about the fact that you are not rewarding disabled employees for not being at work. That offer of a severance package to me would seem to be a reward for not being at work. So why was the case decided in the way that it was? Well, I think it's because, although it wasn't mentioned in the Employment Appeal Tribunal, the size and resources available to Lloyds Bank are obviously something that the tribunal took into account. We see that as part of that initial test. And I think that it's because of the size and resources available to Lloyds Bank that the tribunal expected it to make this promise. I don't think it would necessarily be considered reasonable for a smaller business to have to commit to paying out employees who don't want to work together anymore. And I think it probably also helps in this case that one of the colleagues had already left Lloyds Bank and the other one had gone to move in a completely different department in an office that was far away from Mrs. Hill. So there was no chance of them working together in the future in any event. So on to the next case. This case is about something that used to keep me awake at night when I was working as an in-house employment lawyer. So the HR team would sit around a PowerPoint presentation that had people's names in it in 9 different boxes, depending on how their performance and potential was viewed. And the labels for the boxes at the high achieving end of the diagram were things like rising star and high potential. And then there were other polite labels for kind of generally crap employees at the other end of the box model. So my worry was always from a data protection perspective that if anyone put in a subject access request, they'd discover that they were in a box that they weren't happy with. But the point of the boxes was to determine what level of talent we had in the organisation, and that was to help us then with succession planning for leadership roles. So this particular case is about the discriminatory effect of having that talent pool. The ambulance service had actually gone a step further in this case, and they had a system that meant that you couldn't be promoted to a leadership position unless you had been put in a talent pool. And the idea behind it was to speed up recruitment to leadership roles. So you had a pool of people who were readily identified as being capable of taking on a leadership role. The problem with that was that whilst 12% of the ambulance service employees were aged between 55 and 70, only 6% of the employees in that talent pool were actually in that age group. So what that meant was if you were aged 55 to 70, you were less likely to be promoted to a leadership role. And the tribunal said that the talent pool was discriminatory, but it didn't make any difference because this particular claimant's performance wasn't good enough to have seen her included in that talent pool in any event. And the Employment Appeal Tribunal, when it went on appeal, disagreed with that and said that they were wrong. they found that there were 2 promotions that the claimant hadn't been considered for because she wasn't in the talent pool. The talent pool had acted as an absolute bar to her promotion to those leadership roles. And they said that the ambulance service should have considered whether there was a less discriminatory way to approach the quick recruitment of people into leadership roles. And they said that that could have been done by making membership of that talent pool something that was desirable rather than a condition of promotion. So the moral of the story for me is to be completely transparent with people in appraisals about whether they've been included in that 9-box model, where they sit in the 9-box model, and yeah, all the things that I continue to have nightmares about. There's a way of ensuring that employees are engaged and bought into that process. So onwards and upwards then, from 2020 being the year that we all want to leave behind, we're all glad to see the back of. What are we looking forward to seeing and expecting from the courts in 2021? Well, the first case involves holiday pay, and it's whether a voluntary overtime should be included in the calculation of holiday pay. So we already know that overtime that's guaranteed, that employees have to work, is included, but where employees volunteer for it, does that have to be included in the calculation of holiday pay? And this was a gift from the European courts originally, telling us that where there are people who work vast amounts of overtime in an ordinary week, they shouldn't find themselves being paid any less than an average week's pay when they go on their holidays. The NHS changed their contracts to say that people should be in receipt of average pay when they were on leave. But what we're waiting for in this case is for absolute confirmation as to whether the 20 days minimum holiday that the EU say that every employee should take has to include that voluntary overtime pay anyway, regardless of what anyone has written into their contracts of employment. So then the next holiday pay case we're looking forward to, we're expecting in June of 2021, when the Supreme Court will hear an appeal against a decision of the Northern Irish courts. And this is another aspect of holiday pay. So in the courts in England, Wales and Scotland currently, we say that if there's been a 3-month break between the holidays that people have taken, then that breaks the series of deductions and prevents employees then being able to claim a shortfall in their pay whilst they were on holiday. The Northern Ireland court, on the other hand, has said that the 3-month pay gap shouldn't break the series of deductions. So we're waiting for the Supreme Court to tell us who's right. And obviously, if they say that Northern Ireland are right, then that will mean significant liability for backdated holiday pay claims could arise for all employers. But the effects of that decision will be felt much more keenly in Northern Ireland because in Great Britain, we've put a 2-year cap on claims for holiday pay, for back pay for holidays, whereas in Northern Ireland, they haven't enacted that legislation, so they could see claims going back years. There was going to be a government review of employment laws post-Brexit, but I think it wasn't proving very popular with the Labour voters that the Conservatives are still hoping to win over for the next election. And so that review for the moment has been scrapped. So the last couple of cases that we're expecting to be dealt with in 2021, I know many of you will be watching with interest the case involving MenCap, which will tell us whether national minimum wage has to be paid for every hour that an employee is present at work, even if they're asleep. So where employees are working sleep-in shifts, they are sleeping on the premises and they only have to wake up if there's an emergency situation. Do they have to be paid national minimum wage for each of the hours that they're actually present at work but asleep? So we're waiting for that case. And the last case is where employers have fallen out with a union, they can't get agreement on pay. Is it okay then to go directly to employees to offer pay rises? Until last year, that was unlawful. But last year that decision was reversed, and we're waiting basically to see what the final say is on that case in Coastal UK Limited and Dunkley. So that concludes our session. Thank you very much for being with us for the webinar today. A link to this recording and the slides will be published on our website for you to share with your colleagues if you think they'd be interested. And if you've got any queries about what we've been talking about today, then please do contact Ian and I. Our email addresses are here, so do make a note of them, and take the very best of care, and we hope to see you again soon.